Good day, Crime Talk aficionados. My name is Scott Reisch. Thanks for watching Crime Talk. A big docket today. First, Suzanne Morphew. Some clues that were discovered over the weekend. Let's see where they lead. Second, a memorial for Gannon Stauch also held over the weekend. A good example of what not to do on Facebook. Ignorance of the law is apparently a defense as long as you're a police officer in California. People fraudulently collecting money from victims of a crime. Let's talk judicial philosophy. What's a textualist, an originalist, and an activist? And finally, our dumb criminal contestant of the day and our winner from last week. Let's talk about it. Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk. Thanks for watching. As we stated, we have a busy docket, but before we get started, first, if you haven't done so already, we'd ask that you hit that little subscribe button and hit that little bell as well so that you receive notifications of when we go live. Now, please leave us a comment about what we discuss below. This is going to get good. First, the FBI is called in as a scent of human remains are discovered on land owned by the husband of the missing Colorado mom, Suzanne Morphew. That's right. Her brother organized a search with cadaver dogs at a wooden site 15 miles from Suzanne Morphew's home, and now the police are involved. As you may recall, we talked about this last week. The brother of Suzanne Morphew has organized a search for his sister. As you also may recall, Suzanne Morphew went missing, according to a witness that said that he believed that he saw her getting on her bike to go for a bike ride on Mother's Day. Her husband, Barry Morphew, claims, and I believe that's been shown, that he was at a hotel in Broomfield, Colorado, some 4 hours away. The bike was found, but no sign of Suzanne Morphew. Police search and rescue teams have been looking, but obviously they can't do this 24 hours a day, 7 days a week. They just simply have not been able to find her. Well, Barry Morphew, according to Suzanne's brother, has been somewhat uncooperative with the police, and her brother is taking it into his own hands to see if they can find Suzanne Morphew. The brother, a gentleman by the name of Andrew Mormon, has raised $18,000 to pay for a search that took place over this past weekend, and the cadaver dog picked up on a scent on a wooded site located just 15 miles from the Suzanne Morphew home. A second search of that site took place on Monday using a different cadaver dog, and the dog's handler has told some press that they got another hit. The handler explained that the dogs are trained to only pick up human scents. Now, apparently, because of the hits by the cadaver dogs, the FBI will take over the search and conduct a dig on the area where the scent was detected by the dogs. Now, Mr. Mormon has been in the state of Colorado since last Wednesday looking for his sister. He was being aided by the local police department and investigators from the Colorado Bureau of Investigation, as well as the Federal Bureau of Investigation. Mr. Mormon has stated that Barry Morphew, the husband of Suzanne Morphew, has refused to participate in the search, but did allow the searchers some access to the grounds of his $1.5 million property. Mr. Mormon also revealed that he was told by the FBI investigators that Mr. Morphew's home stank of chlorine when it was searched by the police in the days after Suzanne vanished. It has previously been revealed and reported that Morphew was in a hotel in Broomfield, Colorado when his wife was reported missing. When coworkers arrived at the hotel, they stated that the towels were wet and the room reeked of chlorine. Mormon added to his statement to the press that I know we're in an era of COVID-19, but most people don't clean with chlorine. And he is aware that the hotel certainly did not clean with chlorine as well. Mr. Mormon stated that he was happy with the efforts of the search and that obviously he wanted to do the search before the snow starts falling in that area, which is not going to be too far away. And obviously that would prevent the search. Let's hope there's something positive that comes from this search. And we've said this before. Do you think or do you feel like maybe the walls are closing in? Let me know in the comments below. Next on the docket, mourners gathered together in South Carolina on Saturday to remember the life of Gannon Stauch. As you may recall, Gannon Stauch was a young 11-year-old boy who was killed late last year in Colorado Springs, Colorado, and ultimately his remains were found in Florida months later. His stepmother, Letitia Stauch, has been charged with his murder down in El Paso County, which is in Colorado Springs, Colorado. She is currently undergoing her second competency evaluation, the first coming back that she was completely competent. Well, in positive news, at this gathering, it was held at the Beach Church in Myrtle Beach, and mourners all delivered heartfelt messages about the 11-year-old, including his best friend, who said Gannon always knew how to cheer him up and make him laugh. Gannon's stepsister, Mia, held back tears while she delivered a heartbreaking eulogy. She stated that Gannon was very special and it wouldn't be the same without him. She stated that she loved him so much and she just really wishes that he could still be here.
And I know that there's nobody in the world just like him. And he's very special, and I wouldn't be the same person I am without him. I know he made me a better person. I'm really thankful to have him in my life. I love him so much. And I just really wish he could still be here with us. But I know he is, so.
Pictures were also shown that prove that Gannon was a fighter. Throughout Gannon's young life, he displayed that from early birth when he was a 1-pound preemie who, according to his mother, had literally only a 10% chance of survival. Gannon's father, Al Stauch, left these words that Gannon left the world fighting. But he also said, and wanted to remind us all, hold your children close and love them, because when it's over, and you can't get it back. Good words to live by, ladies and gentlemen. Yes, some days your children can be frustrating. Yes, at the end of the day, you love them. Go hug them, because God forbid something happened to them and you didn't say your last words to them were, I love you. You will forever regret it. Next on the docket, another example of something not to do on Facebook. That's right. Meet Cortez Lamont Edwards of Louisville, Kentucky. Well, he apparently went live on Facebook on September 23rd, to be specific, and he was in possession of a pistol. And that's according to a criminal complaint filed by the United States Attorney's Office for the Western District of Kentucky. And Mr. Edwards now finds himself with a criminal complaint being filed against him by the feds because, first, he was on video requesting money to shoot officers. As you can probably imagine, police authorities are monitoring all of these social activities regarding rioting. Now, certainly if you are requesting money to go harm police officers, guess what? You are going to get the attention of the police authorities. As the police began investigating Mr. Edwards, they had determined that he was in fact a prohibited person. That's right, a convicted felon. That's right. Once one is a convicted felon, they are prohibited from owning a firearm or any sort of explosive device and even other dangerous weapons, depending on the state that you are in. So the agents, who were then armed with the information that they learned from the video, obtained an arrest warrant as well as a search warrant, and they searched Mr. Edwards' house on Sunday. They found him sleeping on the couch when they arrived. They found a gun on the couch and a toddler in the playpen. Mr. Edwards, for his trouble, although maybe he thought he was doing something quite smart, but he almost made a contestant for the dumb criminal contestant of the day, because now Mr. Edwards faces up to 10 years in prison, a $250,000 fine, and 3 years of supervised release, which is basically parole in the federal system, if he is in fact convicted of the charge. This is what we call another teachable moment, ladies and gentlemen. You would think the teachable moment would be, don't go around trying to take solicitations to harm officers. Certainly that is bad. But the real teachable moment here is for all our prohibited persons out there. If you're going to be a prohibited person and you're going to possess a firearm, you may not want to put yourself in pictures on Facebook holding the firearm or videos of yourself at a riot offering to do harm to others, showing the gun while you are a prohibited person. And when the police come knocking, you may not want to have that weapon sitting on the couch with you. Certainly tends to show possession. That's right, possession. Because let's face it, possession can be constructive, i.e. you don't necessarily have to be there, but when it's on your person, makes it a little difficult for your defense attorney to defend. So Mr. Edwards, obviously you're given the presumption of innocence, but next time, don't put it on video. Let's take a quick recess. Crime Talk aficionados, let's say maybe you met someone over the weekend. Do you really know who they are? What do you really know about them? That's right. Go to CrimeTalkSearch.com. Go there, sign up for a background subscription service. Yes, there's a nominal fee, but you can cancel at any time. But when you have that subscription, guess what? You can anonymously search as many people as you want. And when you do that search, literally millions and millions of public records are going to be searched. And you're going to get a report that's going to show you all the emails associated with this person, all the phone numbers associated with this person. So you may ask yourself, why does somebody have 3 phones associated with them? Burner phones? Maybe to keep all the girlfriends not on the same phone, perhaps? How about social media information? See who he's really hanging out with, perhaps. You'll also get criminal background searches, property records, marital records, bankruptcies, all the things you need to know when you're going to be getting involved with somebody. A lot of people sign up for these subscriptions and they do it right after the weekend, right after they meet somebody. Please do not become a victim of someone that you do not check out. It is a nominal fee. It'll be absolutely worth it. Go to CrimeTalkSearch.com, sign up today. You'll be glad you did. Next on the docket. Ignorance of the law is not a defense. Unless, of course, you are an Orange County sheriff. That's right. A couple of Orange County sheriff's deputies who lied on reports testifying that they didn't know it was illegal to falsify reports. Wow. That's right. That's right, ladies and gentlemen. Can you imagine how easy it would be for me and my job if all I had to do was say, my client was completely ignorant of the law. I didn't know it was against the law to harm somebody. I didn't know it was against the law to take someone else's things. Can you imagine me making that defense argument in front of somebody? I would be laughed out of the courtroom. Well, here's the story. In 2019, the story broke of systemic evidence problems at the sheriff's department in Orange County. And what was discovered was that through a sheriff's audit found that deputies routinely booked evidence late into the evidence locker. The probe, covering the period from February of 2016 through February 2018, found that 27% of the deputies waited at least 31 days or longer before booking evidence into the locker. You may ask, well, what is the big problem about that? Well, where has that evidence been for the 31 days that it's been floating around? Has it been, kind of weekend at Bernie's? Let's take the drugs with the family on the trip to the lake. Let's take the knife out and, maybe use it to cut a steak or something. Who knows what's being done? It goes to the integrity of the evidence that's being collected. In this particular case, nearly 300 items did not get booked for more than a month during this audit period. A second review determined that there was a sampling of some 450 reports and found that deputies in 57 cases said they had booked the evidence in when actually they had not. Why is that important? Well, when the prosecutor and the defense look at the evidence, they need to see if the evidence is there. Can you imagine the prosecutor saying, oh, the evidence is there, and then it's gone, it's not there for trial? That could be a problem. Can you imagine the defense saying, we'd like to test that evidence, we'd like to go view it. Oops, it's not there? That's a problem. That's a problem for everybody. Well, 2 officers in this particular case were convicted of lying on their police reports, and they recently testified before a grand jury, and they stated that they didn't know it was illegal to falsify these documents. That's right. Officer Joseph Anthony Atkinson and Bryce Richard Simpson had neglected to book evidence but falsified the reports to say that they actually had. The once routine practice at the Orange County Sheriff's Department of booking evidence by the end of their shifts as required by the department's policy was ignored for years in hundreds of cases where evidence was booked late or not at all. Atkins and Simpson were considered some of the worst offenders in the department, according to the reports. And they were allowed to plead guilty in June to a misdemeanor charge because if you're a felon, you can't be a police officer because you can't carry a firearm. So we can't do that. So let's just give them a charge of a misdemeanor so that they can still be a police officer, even though it's for dishonesty. Atkinson and Simpson recently testified during the recent grand jury hearing for another deputy, Edwin Mora. He rejected the plea deal and was subsequently indicted on a felony charge of falsifying a police report. Now, Mora is a former 19-year veteran who wrote in a 2017 report that he booked a knife, methamphetamine, and glass smoking pipe into the evidence locker when he had not. This is where Atkinson and Simpson told grand jurors during Mora's hearing that they had never been trained on a penal code section making it illegal to falsely write in their reports that they had booked evidence in when they had not. And as you can imagine, some of the grand jurors apparently were shocked, but the prosecutor told the grand jurors that he gave the plea deal to Atkinson and Simpson partially because they had not been informed of the penal code section for lying on an official report. I'm not exactly sure how these officers were supposed to get this information. You and I are held to the standard of if the law is passed, you are put on notice of it because, after all, it's in the library. You could look it up. But apparently, if police officers didn't receive exact formal training on that particular section of the penal code, then they are not held accountable. We don't have anything in particular against police officers. We just have something against bad police officers. And guess what? We have something against bad prosecutors that allow bad police officers to stick around. And we have a problem with judges that allow bad police officers to stretch the truth, falsify, and be completely incredible on the stand and still not be called out for it. That's what we have a problem with. And for these officers to get away with this is simply outrageous. And sometimes people wonder why people don't trust the criminal justice system or those who work in it. It's because of cases like this where wrongdoing is done and people are given a much better disposition based upon their authority in the law or in life. And guess what? It shouldn't work that way. Remember, Lady Justice was supposed to be blind to everything. Simply look at the facts and the law. Next on the docket, do you remember the Florida Massacre where a couple of guys were going out fishing and had a little altercation at the dollar store? And guess what? They were all basically found by the police and a family member deceased. That's right. Well, that was the case regarding Brandon Rollins, Kevin Springfield, and Damian Tillman. They were all found beaten and shot to death on July 17th at Lake Streety. That's about 70 miles east of Tampa, Florida. 2 brothers and a woman living in the area were, in fact, arrested for the murders. But like all tragedy, there are people out there that are going to take advantage of it. and a Florida woman was arrested for allegedly pocketing money she raised on a GoFundMe supposedly intended for the families of the 3 men murdered. A relative of one of the 3 men killed contacted the Polk County Sheriff's Office to report a fraudulent account on August 10th. The relative received a Facebook message link to the GoFundMe page, and the relative advised her followers to report the account as fraudulent. The account was titled the Polk County Triple Homicide Family Expenses, and that was quickly deactivated by its creator, but it had managed to raise nearly $12,000. The money was entirely spent in stores in Central Florida and online, and it was used to pay bills, according to the sheriff's office, based upon their investigation. The sheriffs identified Amanda Brown, and will certainly give her the presumption of innocence, as we do everyone we talk about on this particular channel, so that they receive that presumption until and if they are actually found guilty by a jury or plead guilty in a court of law. Now, the detective said that Miss Brown stated she created the account without authorization, intending to give money to the families listed on the account, but she spent it once she began receiving the funds. She also admitted to uploading all of the information to the website. The official amount taken was $11,505.39. It just shows you, ladies and gentlemen, you have to be careful, even when people you think are trying to do something good. As someone who is an eternal optimist, my glass is always half full. But I'm telling you, some days it really questions your faith in humanity when you hear stories like this, where someone has literally taken advantage of the death of 3 people. It's disgusting, and it really makes you wonder, why would people think that that would be okay? Let's take another quick recess before we continue on with the docket. Now, there's been a lot of information, and we started talking about this the other day. The Boy Scouts of America have filed for bankruptcy protection. Why did they file for bankruptcy protection? Because they had a lot of claims against them for allowing and knowing that people were doing inappropriate things to young scouts. Now, there's a lot of people out there that are very good that were in the Scouts. I was a young Cub Scout. I think I even made it to Webelos, if I was correct in my memory, but I never went on to anything beyond that. And no one ever did anything appropriate with me, and frankly, it was a good experience. But let's face it, like in lots of organizations, there's lots of bad people. So if anyone who's out there watching, it was either personally or knows someone who was subjected to verbal abuse, inappropriate touching, derogatory social or racial comments, unnecessary photography, or verbal or physical threats, you should go to CrimeTalkBSA.com. That's right, CrimeTalkBSA, BoyScoutsOfAmerica.com, and fill out the information to make a potential claim. These claims must be made no later than November 16th of 2020 so that they qualify under the $1 billion settlement fund that has been set up by the Boy Scouts of America. They acknowledge inappropriate things have been done, and you can make a claim even if you've never reported it to anyone. Go to CrimeTalkBSA.com and fill out the form there today. All right. Next on the docket, let's talk judicial philosophy. Now, the reason why we're bringing this up, obviously, Ruth Bader Ginsburg, Justice Ruth Bader Ginsburg, passed away recently, and her replacement, Amy Coney Barrett, has been nominated by the president to take her spot. And there's been a lot of debate whether that's appropriate or inappropriate, but we're not going to talk about that debate. That's political stuff. Let's talk legal stuff. Judge Amy Coney Barrett sits as a judge right now for the 7th Circuit Court of Appeals, and she has described herself as a textualist. And what exactly is a textualist, right? You would think that every judge should read the text of the law and follow it, giving plain meaning and effect to the ordinary meaning of those words. And that is the definition of a textualist, is a judge that relies solely on the literal or plain meaning of a text and does not consider supporting or supplementary sources such as modern social policy or legislative history when interpreting a statute. Some people may get confused and say, well, what's the difference between a textualist and an originalist? Well, a textualism refers to the literal interpretation of the language of the Constitution and of its scope, whereas an originalist resorts to the non-lexicographic criteria, primarily history and the founders' political writings, to purport that certain propositions is in line with what the founders of the nation had in mind. All right, straightforward enough, correct? And then you have what some people refer to as judicial activism. And that is the philosophy that the courts can and should go beyond the applicable law to consider the broader societal implications of its decisions. It's sometimes used as an antonym of judicial restraint. It's usually a pejorative term implying that judges making rulings based upon their own political agenda rather than precedent and take advantage of judicial discretion. So let's take a quick look at this. So very quick, why would this matter? All right. Well, obviously, every judge takes an oath to support and defend the Constitution. And as we all know, the legislature makes the laws and the court interprets them and the executive branch enforces them, implements the laws that are passed. Nobody other than maybe Congress, if they don't like the laws, shouldn't pass them. But if they do, that becomes the law. The president, the executive branch, has to enforce them whether they like them or not. If he doesn't like them, you don't get to say, I'm not going to necessarily enforce them, but you have to go back and say, Congress changed the law. Same thing when it comes to judges. Judges are there to interpret the law. Because let's face it, the legislatures usually draft poorly written laws. Not just the states, but Congress as well. Otherwise, we'd have no reason for the courts if everybody knew exactly what was meant by the laws written by the legislators and Congress. So when a question comes to a judge, the question should be, and oftentimes it's referred to as a textualist or as an originalist, as somebody who's an umpire. A judge should be an umpire, simply calling balls and strikes and saying, don't care where this decision comes down. That's just the way it is. If you don't like the law as it is written, then the legislature needs to go back and fix it. Think about it as the analogy as it relates to a baseball umpire. Could you imagine if an umpire was out there saying, I'm really a big Yankees fan and we really don't like Boston, so the strike zone's going to get real tiny when Boston is out there pitching, right? You would think that that's not a good thing. Why would the judge be unfair, showing bias? Exactly. Well, what if you had an umpire that said, I got to tighten up this strike zone because guess what? I may not make it out safely tonight out of the stadium if the fans don't like a particular result. So I'm going to do it based upon my own self-interest or maybe the good of the city so the place doesn't burn. Well, a judicial activist baseball umpire would be just as unfair as a judge. Why do people like the United States? Certainty, ladies and gentlemen. They like the laws that are written. When they say you can't do A, you must do B, that's what it means. But if somebody goes in and says, I did A and I had to do B and I did it, how can I be in trouble? And if the judge says, well, you just are not the guy that we're looking for. And frankly, the legislature didn't think of all of the possible circumstances. So therefore, I'm going to just kind of rule from up here at the bench and allow my decision to go forward. And you get screwed today. You followed the law, but you're going to get screwed today because I, as a judge, have decided that it is unfair. You would think that is unfair. Now, maybe you wouldn't think it was unfair if you were the guy that was maybe getting the money from the fine or whatever it was that he got screwed by, right? But then that's bad for everybody else, because if you don't know what the law is, even though it says clearly what it states, then that's not fair. Let me give you an example. I've used this before. I had a suppression case in a homicide once, and I said, Judge, under this particular kind of search, the police had to do A, B, and C. Not an or, but they must. They shall do it. Mandatory. And the judge literally looked at me and said, well, there's some case law out there that says that the and could be an or, right? So it changes. You must do it, all three, versus you can do some of these or one of the last item. I looked at the judge and I said, that would be completely intellectually dishonest to do that. Well, guess what? The judge ruled against me, changed the and to the or, because she didn't like my client. My client was accused of very bad things. But instead of being a textualist and saying, sorry, police officers, you were supposed to do A, B, and C, and you only did A and B, but I'm going to change the language in the law to help you today because we can't have bad guy go free. Well, guess what? That's wrong. That's judicial activism. They're rewriting the statute in that particular case. For what reason? Because the judge didn't like my client, wanted to help the police out? It's not fair, ladies and gentlemen. People rely upon the plain meaning of the words. And if you go change the meaning of the words, that's great. And I'm going to complete candor. I have gotten up there in front of the judge and said, yes, in this particular case, you shouldn't look at the plain meaning of the words. Judge, you need to look at the overall circumstances of it. Yes, I've had to do that for my client. But guess what? Judges usually reject that when it's coming from the defense. The point is, ladies and gentlemen, words have meanings, simple, plain meanings. And you don't have judges rewriting the law to fit their set of morals and values. That's what the legislature is there to do. If you don't like the result of the judicial interpretation of a law, you can change it, assuming it's constitutional. But that's where the remedy is changed, not the judge. When a judge starts rewriting the law, that is what we refer to as judicial activism. And it's not a good thing for anyone because it creates a sense of unknown and uncertainty of what the law is. If the law may be clear, but then it completely changes depending on which judge you're sitting in front of, how is that good for anyone? How is that good for society? It can't, because then you have a judge acting as a super legislator deciding what the law should be. I hope that explains those philosophies. Now, an originalist is someone that says, yes, you need to look at the plain meaning of the words, but if you need to know what those words mean, then you go back to the time the document or the law was written. You don't get into legislative intent. You don't get into socioeconomic studies of today. You look at the words of what they meant at that time that the drafters used. You don't say, oh, well, we're going to change what that means based upon today's term and usage, right? Doesn't make sense. Could you imagine if you bought a house and your deed had particular language in there and you relied upon that because that was the language written at the time of the deed, and one day the judge says, well, that really doesn't mean what it meant back then. So therefore, sorry, Mr. Homeowner, we're going to take away your property rights because we don't like the meaning of that word. And it's so old and it's so long, long ago. But you'd say, but that's what the word is. It says it right there, and it's plain meaning what it means. You would want to go back and say, look, here's a dictionary at the time, and this is what the definition meant at the time. That's what an originalist does. Plain text. If you can't figure out what they meant, you go back to the time that the document was drafted and give plain meaning and effect to the word at the time, not today's present meaning. Hopefully that's as clear as mud. We tried our best. All right, next on the docket, our dumb criminal contestant of the day. But before we get there, who is our dumb criminal contestant of the week? That's right, let's give it up for Justin, the man who decided to put a loaded firearm up his anus to avoid having that firearm found by the police officers. But of course, they did when he was being booked in. Justin, congratulations. We'll track you down. We know where to find you, and we're going to send you a Crime Talk mug. Maybe Justin would like to contact us before we send him a mug, just so he knows he may even have a choice if he calls us. And maybe we could even get him to provide a little insight onto why he thought that would be a good idea. I'm not really sure. But if you want Crime Talk merchandise without having to become a dumb criminal contestant, hit the link below, go to Teespring, order your merchandise today. Now, let's meet Robert Otis Hoskins. He is our dumb criminal contestant of the week. Certainly, we give him the presumption of innocence, but apparently, Mr. Hoskins didn't like when the police showed up. The police responded to a residence and found Mr. Hoskins, who was only wearing a pair of gray briefs outside of his residence next door to the burglarized property, allegedly, of course. And as the deputy sought to question Mr. Hoskins, he began shouting at the police and approaching him with a book in his right hand. The book turned out to be the Bible, and as Mr. Hoskins approached the officer, he stated something to the effect of, "I condemn you," and then tossed the Bible at the police officer. Of course, what does that do? That causes pain to the police officer, whereupon a crime has been committed. Needless to say, Mr. Hoskins was taken into custody and charged with a sundry of crimes after a brief scuffle. Mr. Hoskins' wife told the deputies that he does seem to have a drug problem. Oh, really? Now, that apparently became quite clear when he allegedly broke into the neighbor's home to free the victim's juvenile daughter. It's unsure exactly what he was freeing her from, but in his skivvy drawers, one would think it was something to do with perhaps her virginity. Just when you think it couldn't get any better, that's right, Mr. Hoskins found it necessary to defecate on himself at the crime scene. And of course, he unsuccessfully tried to bolt from police officers when he arrived at the county jail. Mr. Hoskins, you, my friend, are our dumb criminal contestant of the day, and may the good book be with you. That's all we have for you today. Don't forget to join us tomorrow at 6 p.m. Mountain Time as we go live for our weekly live show. Please join us. Have a great day. We'll see you tomorrow on Crime Talk.